very specific provisions and raise the issues. I am first taking section 3.3 and for the benefit of rail readers, it is at page 9. It is at page 9. Now, 3.3 reads, in fact, after amendment which has been suggested by the government, it would now read, no person with disability shall be discriminated on the ground of disability unless it is shown that the impugned act or omission is proportionate. No, in fact, appropriate has been removed in the amendment which has been circulated. Proportionate to achieve a legitimate aim. Now this, I have two issues here. By retaining this section, are we not recognizing the power of the government to discriminate on the ground of disability in certain eventualities? Furthermore, are we not allowing a subjective approach to decide as to which act would constitute a discrimination and which act would not, by giving a scope to the executive to justify its impugned act or omission on the ground of so-called achieving a legitimate end and it was proportionate to do that? It would probably, tomorrow, if it goes to the court, a given case goes to the court, to illustrate, if supposing a blind, which we have been, in fact, in real life, litigating on these issues. A blind is denied or a post of teacher is not declared as identified or suitable for person with blindness. There is a history of litigation around it. Gujarat, if someone has come from Gujarat, he would know better. This litigation started there. Now, if this provision is retained, fortunately we don't have any provision of that kind in the existing act. If in the bill you provide this unless part, one will say, no, the quality of teaching will be reduced. No, we will have to make certain adjustments and modification in the classes and the procedure of teaching, which would require so much, which would impose so much burden that it is proportionately not justified, and the aim is to maintain quality, therefore it is a legitimate end. Therefore, blind will not be offered the post. When Article 14 of the Constitution, 14 to 16, does not make any provision to the right of equality, why should this? What is the justification of keeping this? I was really shocked the other day when we were in a television interview on NDTV, and one of our friends, activists, was justifying the retention of this clause, unless clause, and was speaking more than a government spokesman rather than a disability activist or person with disability. So that is one point that I want to flag. Now coming to the other thing. On employment again. Let's go to the employment, not again. On employment, I would like to refer to the sections section 33. And in this section, if you have section 33(1) is all right. But here also I have an issue with which I will come in the employment chapter. Now let's go to the section 33(2), provision. 33(2), page number 36 for grade leaders, provision. Provided that if the nature of vacancy in an establishment is such that a given category of person cannot be employed, the vacancies may be interchanged among the given categories with prior approval of the appropriate law. That means what? This means that if 1% reservation is for, say, intellectually disabled. Now, this government has the discretion to change, to divert this 1% in favor of, say, blind. At the threshold, I could understand the interchanging principle against carry forward. But it is at the threshold itself. Tomorrow government may say that look, and which will happen, that look, group A and B vacancies are not available to intellectually disabled at all. So that percentage will be diverted to someone. Is it not a discrimination? How can you do that? And why? After Supreme Court judgment, 8th October judgment, is it permissible? It is to negate that judgment, that this principle of the empowering the government is given.